So obviously everyone is awaiting, Alicia, a decision on those affirmative action cases. There were two cases, one dealing with Harvard College's undergraduate admissions protocol and one dealing with the admissions protocol at the University of North Carolina. Both of these cases, if oral argument is any indication, will dismantle affirmative action. The court seemed inclined to do so at oral argument back in November. If that is the case, it will set off a ripple effect where we're going to be rethinking affirmative action policies, not only in higher education, but in the administration of higher education and possibly even in private employment. So this is a major, major decision that will reshape the landscape for our kids who are applying to college and possibly reshape the landscape for a range of different decisions in environments that are viewed, where diversity is viewed as being paramount and important.
Yeah, I almost think looking at this list, it's like obviously these issues affect a very broad swath of people. Specifically, often we talk about student loans as though it is a young person's issue, when really it's an issue that affects people all across ages, all across generations. But you look at that list, those are a lot of things that motivate young voters. I want to ask you about the court's ruling on the Indian Child Welfare Act, because you had Justice Gorsuch joined the liberal justice in the majority, and our friend and the nation's Elie Mystal describes Gorsuch as the Supreme Court's fiercest defender of Native rights, and at the same time points out his attitude does not extend to African Americans or other minority groups. I wonder if you agree and how you explain it.
So let me first go back to those other cases. It's not just affirmative action. The student loan case is going to be enormous in terms of economic opportunity, not just for young people, but anyone who has taken out a student loan over the past 20 years. And then, of course, there's that question of LGBTQ equality pending in 303 Creative versus Elenis. So there are a spate of civil rights decisions that the court's going to put down. We saw a really unexpected victory in the Indian Child Welfare Act. That's a 1978 statute that was passed with bipartisan support in order to remedy the historic removal of Native American children from their tribes and their placement in non-Native homes. And as you say, Neil Gorsuch has turned out to be a surprising champion of Native American rights. And again, I'm not so sure it's surprising. Justice Gorsuch is one of the justices who does not hail from the Beltway. He's actually from the Mountain West, Colorado, the 10th Circuit, where there's actually a very active docket of tribal issues. So this was something that he knew as a judge on the 10th Circuit, and he's imported that here. More importantly, Justice Gorsuch identifies himself as a textualist, meaning that he cares a lot about the text of statutes, the text of the Constitution. Much of federal Indian law is governed by treaties between Native American tribes and the federal government. So there's a lot of textual support for these rights. And so when Justice Gorsuch comes out in favor of the tribes, it's often because there is textual support for him to do so. Elie Mystal is exactly right. It's probably unlikely that we're going to see Justice Gorsuch coming out with the same kind of vehement defense of rights for other minority groups. Again, their tribal rights seem to be a very special situation here.
This is going to be such a busy and impactful week. I want to ask you about an interesting ruling this past week on jurisdiction. The court ruling, if lawyers bring a case in the wrong district, they can retry it. This is particularly interesting, given what we just saw with special counsel Jack Smith bringing charges against the former president in Florida instead of Washington, D.C., instead of New Jersey. I wonder, knowing what we know now, if you think that would have in any way changed Jack Smith's calculus?
Oh, I think it changed it in every way, Alicia. I actually said this on the night that Trump was indicted on Chris Hayes' show. That case was argued on March 28th. It's pending on the court's docket. And basically, the court just came out with its decision, but it hadn't entered its decision at the time the indictment was announced. And again, if that case had been charged in the wrong district, it would have made it very difficult to recharge it in the appropriate district going forward. So I think Jack Smith, knowing that the case was pending, not knowing what the outcome would be, decided to just hedge his bets, charge this case down in the Southern District of Florida to ensure that there wouldn't be the need for a do-over that would not be possible if the Supreme Court decided this case in the way that they ultimately did.